To both companies engaging in a pay-for-delay agreement, it can seem like a win-win, but the ones really paying the price is the patients struggling to afford their medications. In 2019, a group of HIV and AIDS advocates filed a lawsuit against Gilead, arguing that this deal was a clear violation of antitrust law and an illegal effort to extend the life of their patent, which has led to a public health crisis. This gross over-profiteering explains why less than half of the people living with HIV in the United States are virally let's see. So at first glance, one would think this would be an open shut case of collusion, since the Sherman Act, the federal antitrust law statute, clearly outlaws agreements between rivals not to compete. However, due to a 2013 Supreme Court decision in the Federal Trade Commission versus activists, pay-for-delay agreements are no longer per se illegal, but subject to the rule of reason standard, which considers whether the collusion actually harms the consumer, and if it does, whether the business had good reason for it. The activist decision provides plenty of wiggle room for defendants to argue their way out of collusion charges using speculative business theory. Under this reason, the court found that Gilead's 2014 patent deal with Teva did not violate antitrust laws. This decision lets corporations know that these types of collusive agreements will be held up in court as long as they can argue around it, thereby assuring the continuance of these patent deals, delaying generic drug alternatives for years to come.